Get ready for the dictation. Start. By the impugned judgment dated July 7, 2006, the High Court of Madhya Pradesh, affirming the judgment of the trial court, has upheld conviction of the appellant Udiya under section 302 of the Indian Penal Code 1860 for murder of his brother Nakuda and sentenced him to imprisonment for life and fine of rupees 1000, in default of which he is to undergo rigorous imprisonment for 1 month. Having considered the testimony of Jeevani PW1, wife of deceased Nakuda and sister-in-law of the appellant, who is an eyewitness, we have no hesitation in affirming conviction of the appellant for having caused death of Nakuda. Jeevani PW1 has testified that on July 10, 1999 at about 10 p.m. while she was in her house, she heard her husband raising alarm. Her brother was returning from work and was at a short distance from home. She had seen the appellant assaulting Nakuda with a stone. Nakuda had also told her that the appellant had assaulted him with a stone. Jeevani PW1 had thereupon proceeded to the house of one Lakshman and took him to the place of incident. Villagers had thereafter gathered at the place of incident. PW1 had lodged the police report exhibit P/1. In fact, while issuing notice in this appeal void order dated February 23, 2009, the same was confined to the nature of offence and quantum of punishment only. We would therefore now address the question on nature of offence and quantum of punishment. Medical evidence in the form of post-mortem report provided by Dr. Nirmal Kumar Chaudhary PW6 opines that the deceased had suffered contusions and a fracture on the left temporal and maxillary bones, and that the death was on the account of the head injuries. However, he was inclined to accept the plea and contention that the present case would fall under exception 4 of section 300 IPC. This is not a case of premeditated attack or violation actuated by a motive and previous feud. It was a case of sudden fight in which the two brothers got involved, and in the grapple the appellant had picked up a stone and had hit the deceased Nakuda. Birji PW3 had testified that Jeevani PW1 had come to his house and stated that the appellant and Nakuda were fighting. Similar assertion was made by Lakshman PW4, who has stated that Jeevani PW1 had informed that the two brothers were fighting and that they must separate them. Appellant had not come armed to the spot with a weapon of offence. No witness has testified as to any past enmity and acrimony between the two brothers. In fact, Jeevani PW1 had stated that earlier a civil suit had been filed by his deceased husband and the appellant against two other persons, and that there was no previous enmity between the two brothers, though they sometimes used to quarrel and thereafter would become friendly. When Jeevani PW1 had approached the deceased Nakuda, he was in a position to speak and had stated that the appellant had given him a beating with a stone, albeit he did not give any reason for the violence. Post-mortem report no doubt refers to fracture of the third and fourth rib, but these could have been caused when Nakuda had fallen down. No external injuries were present and noticed in the rib area. Lakshman PW4 has disposed that they had proceeded to the appellant's house. Appellant, who was present, was asked to come out and was thereupon confronted and informed that Nakuda had expired and they would be filing a police report. Then the appellant, on the pretext of easing himself, had fled from the spot. This would indicate that the appellant was not aware that he was killed his brother Nakuda. Even otherwise, there is hardly any evidence to suggest and show that the injuries caused were intended so as to indicate intention of causing bodily injury, as is sufficient in the ordinary course of nature to cause death. Stop.